In this video, I will talk about with a specific view to the law of England and Wales. So for those of you who are coming from other jurisdictions or even from other common law jurisdictions, just be mindful that the same principles, the principles basically discussed in this video, they are discussed based on how they are being applied by the courts of England and Wales, whereas other jurisdictions, they might apply them, but they may apply these principles not in the same way as the courts of England and Wales would, or they may not apply them at all. Before I continue with the example, I wanted to issue a disclaimer saying that no liability should be assumed, and whatever stated, the contents of this video should not be relied on as advice or legal advice of any sort in any circumstances. So, having done that, there seems to be in England and Wales a quite controversial established body of law, which states that when a principal does not know, right? A principal does not know that a representation is taking place, and that it's mostly a question of fact. Then when he appoints an agent, right? He appoints an agent. The agent makes a representation, although not fraudulently. That's basically lacking the necessary mindset to qualify his representation to a fraudulent representation, or otherwise known as deceit, right? Then this principal will be innocent of. It will be basically innocent and will not be liable in deceit, which means probably an exclusion clause, which was signed as a contract by a third party, and the agent on behalf of the principal will not bind the principal since there was no fraud involved, and the basic rules of fairness are going to apply in regards to the exclusion clause, whether it was fair and whether its language was readily understandable in relation to the subject matter of the contract, right? And you have to understand that if you go down that path, it's going to be a hell of a lot more difficult than if you just prove fraud. See, because fraud is going to override any entire agreement clause or any exclusion clause, because there's a principle that states that nobody can really benefit from his fraud by just including clauses here and there within the contract. So you can imagine if the agent is being innocent, right, and he makes a representation innocently, then just because he didn't know or he was ignorant of the truth, and the principal did not purposely told him about something that might just come up, then the question arises of whether the principal will get away with fraud or it wouldn't get away with fraud if the principal knows of the circumstances that make the representation that the agent made was actually false, right? So the necessary element in proving the connection with the misrepresentors, the agent's mind, and the fraudulent mind of the principal will be the knowledge of whether the representation was going to take place, right? And this is like this is quite hard to prove. There are cases that constitute live examples of how difficult that was. One of the cases is Cornford versus Folks, which has come under severe fire from other jurisdictions, in which basically it was held that a principal, because a principal which stated that there were no objections with the house after it was questioned, it was asked to answer to a third party purchaser who was going to purchase the house. He told him that there were no objections, and this was because he said so because he didn't know. The principal was not held to be fraudulent just because he didn't tell him, or just because he didn't know of the knowledge. He didn't have knowledge of he had basically knowledge of the falsity of that information. What he seemed to lack, where it wasn't at least proved, was that the principal didn't know that a representation was going to be made. It's quite controversial because in a case like that, just because the knowledge wasn't proved, the principal got to get away with fraud, basically. Because, but that again is it's really it's actually debatable. Because we live in a free world, and you have to. There's a principle called caveat emptor, so you gotta you really gotta know. You gotta do your research before you enter your contract with someone. But in a case like that, one would also expect the agent to have made to be at least to be held to be fraudulent. But there is the catch, because it actually made a representation. It didn't know that whether it was true or not, right? It said, it was asked whether there were any objections with the house, and he just there were no objections, whereas there was like a brothel. Basically there was a brothel, in the neighborhood, I think like a block away or something like that. So it would have been something material which would basically induce the third party to enter the transaction, the contract. The agent was innocent because he innocently believed that he was going to be told about that, or just perhaps because there was no dishonest element found. Someone would just basically thought that he was going to be told about that, whether there were any objections with the house or not. It just wasn't told. So one more dangerous feature which makes this kind of scenario when you have to deal with an agent on behalf of a principal is that you may be risking sacrificing a claim in fraud, because even if the agent says something which he doesn't know of, right? He may not be deemed to be reckless, and and as a result fraudulent, which with recklessness being the second head of a form of dishonest mind, in relation to the making of a false statement, right? And this was also held in the case of lead bidder versus love, where the son was acting as an agent on behalf of his father. He wasn't told that the sheep that he was going to sell were affected with rot. He made a representation that the sheep was good, it was okay, and again, in that case though, that case was decided. It was decided differently than the Court versus Folks case. It was said that the principal should have expected a representation to be made. So that's basically the key. You should know whether a misrepresentation can be made or not. But then again, there's something that really does strike me as very concerning, is the fact that the agent was not found reckless, despite the fact that he didn't know of the falsity. He didn't know whether the statement that he made was true or not. or maybe some ground of support may be found in the argument that he did actually honestly believe, his father he was actually going to tell him about this situation. He was going to tell him about the sheep. He was actually going to sell the sheep to someone else. So he kind of honestly believed he wasn't reckless within the legal sense, right? So, how do we draft, and how are we careful? How do we get to counter a situation like that when we're drafting a pleading, we're preparing our case, and it is absolutely essential for us to prove fraud, deceit, just because maybe we want to overcome an exclusion clause, or maybe we want to claim extensive damages, which are all exclusive benefits which come only with the tort of deceit. Well, first of all, you need to really know your case. You need to know your facts. You need to gather as much information as possible and know what really happened. As was said in the case of Cornford versus Folk, someone who basically encourages, someone who authorizes, someone who procures, someone who basically encourages, a fraud, or a statement of basically a statement of similar import to the misrepresentation, a principle basically, he will be held liable for fraud. So you have to tackle the problem at its root, and you got to prove the knowledge, because this is basically the missing link between the one hand the misrepresentation of the agent, of an innocent agent, and the dishonest mind of a principal who basically knows that the misrepresentation is, there's a likelihood that it's going to be made. Otherwise, you're going to be barred by the case of Armstrong versus Strain, which basically says that you cannot add one innocent mind, which will be that of an innocent agent, to another innocent mind, which will be that of a principal, who basically doesn't know that a representation is going to be made. He doesn't know under the circumstances. And a good argument for the result of Cornford versus Folk and Armstrong versus Strain is that, is by placing reliance on the kind of representation that was made, and arguing that it was kind of impossible to know, or it was not really reasonable to foresee that such a representation was going to be made. There's been another case, it doesn't really come to mind right now, where there was this salesman, he was selling cars. He was asked, whether they were secondhand. He was not being told that the specific car was about to be sold. It was going to be, it was involved in an accident before. He was asked about it, and he lied. Well, he actually lied about it, and that was fraud on the part of the principal, just because the principal should have expected that a representation in this kind of context, under those circumstances, a car dealership was going to be made, because he was going to be asked a question that was going to be called for, and the person also had ostensible authority, so he was going to reply. So he didn't really know only of the falsity of the information. He actually he actually did know that a representation was going to be made. Now, you need to basically tackle the problem at its root, because there are principals out there, and big corporations who will take every possible measure in order to forthcomingly safeguard themselves legally when they're about to be they're about to be sued in deceit. there are very sophisticated principals out there who will, for example, put a prohibition place a prohibition upon certain agents' power to make representations. So they will basically decrease their chances of being shown to have known whether a misrepresentation was going to be made, right? And on the other hand, in subtle means, they might just encourage it at the same time. And it's very important for the plaintiff and for the plaintiff's practitioner to sort of prepare himself, know whether the plaintiff knew, whether the agent knew or he didn't know of the misrepresentation, whether the principal communicated the prohibition to him through different rankings of agents and employees within the corporation, and if he knew of the prohibition and he was ignorant of the fact, that what he was dealing with, and he really didn't have ostensible authority to bind, let's say, a third party, then a question should be asked of whether the principal basically procured the fraud, because you're just placing a prohibition there. But on the other hand, when you give ostensible authority to an agent to sort of communicate that he can answer questions, a question is raised as to whether he knew that a misrepresentation was going to be made or not. Then again, another difficulty arises, because having someone who has ostensible authority is a factor that's decisive, basically, of the fact of whether an agent can bind a third party. It has not been held as a factor that can be held to a factor basically that could be taken to effect. Could fix basically the principle with knowledge of whether a representation may be made. But in the grand scheme of things, you should prepare to know and possibly argue a case of both vicarious liability, which I haven't touched in this video, and primary liability, which is basically proving the principle wrong. Because with vicarious liability, you may not really have a chance, since the agent is most probably going to be innocent if he has not been told of that possibility when he makes a representation. Proving the representation, of course, another challenge, which I will address in a different video. Thanks very much for watching this. I'll see you on my next video. Bye.